Let's talk about the puffery, the legal definition. In law, puffery refers to exaggerated, subjective, or boastful claims made by sellers that cannot be objectively verified because reasonable persons understand these statements are harmless sales type rather than factual promises. They are not actionable. It cannot form basis for fraud or false advertisement. And this is what they use. Fox News won in part, and Tesla won in part some lawsuits against them by the reasonable person standard, which is the statement is so exaggerated that no ordinary consumer would take it literally or rely on it when making a purchasing decision. Okay, and that's why I've always objected to these people running big businesses running for office because they take that puffery from the boardroom to Congress and otherwise. Okay, so in a legal sense, I put about our laws legally required to be in the public interest. In a legal sense, no. All laws are strictly required to be in the public interest. Instead, they must be constitutional and pass through proper legislative process. While most legislation aims to promote the general welfare, public interest is subjective and can be heavily debated. Now, listen why. The difference in practice, legislative standard, lawmakers are elected to represent their constituents, meaning they generally try to align laws with the public interest. However, the law itself doesn't become invalid because a portion of the public disagrees with it or views it as not serving their best interest. So when it comes to the public interest, it has to serve the interest of the public as a whole, not as a small portion, 10%, 2%, 5, 15, 25. No, it has to be effectual for the public in general, okay? The constitutional standard in the United States, the ultimate test of law's validity is its adherence to the Constitution, not its popularity. If the law is constitutional, it stands. And I always stood for that. And I always stood for the Constitution. And anytime anybody refers to it when they speak of it, I hold them to the letter of the law. Some people like to reinterpret the Constitution, telling what they think it means, totally devoid of the letter of the law, which there are penalties of that, which creates disinformation, which there are penalties for lawyers and judges. Okay, administrative law. Public interest is often used as a standard for government agencies like the FCC when granting license or creating specific regulations, but this is a guideline for agency discretion rather than a universal requirement for all laws. But generally, you can use, laws are actually supposed to be created in the public interest, but as a majority, the majority, not a small minority, okay? And this is why things aren't happening the way they should be. Okay, corporacy. It's a political and economic system where large corporations, conglomerates, and business interests hold disproportionate power over the government policies, public life, and the economy. In the system, corporate influence rather than citizens' needs determines the state's priorities. Okay, so there's a lot to be said about corporacy, and you should look it up. Under the color of law refers to an action taken under the appearance of legal authority, even though the conduct itself is illegal or an abuse of power. It typically applies to government officials or those acting in cooperation with them. Civil violations, private citizens can sue. Criminal offense, make it a federal crime for anyone acting under the color of law to willfully deprive someone of their constitutional rights. And it says so with the Department of Justice. But any lawyers and judges not abiding by or enforcing the rules of professional conduct or the code of judicial conduct is deprivation of rights. And them working together, because everybody's supposed to report misconduct. Everybody's misconducting, and nobody's reporting. So failure to report misconduct is misconduct. So that concludes this conspiracy against rights under the color of law. Okay, people, remember, under the color of law, it's a legal term, meaning it's abuse of power. They're using their power to violate your constitutional rights. And that's against the law. That's deprivation of rights under the color of law. As you see, it says here with the Department of Justice. All right, so it's going to take more than... I've been, as they call it, playing with them for a very long time. And once you get to know what you know, just look it up. Ask the Department of Justice. Take care of their business. Do your job. You took the oath to do this. Violation of the oath of office occurs when a public official, law enforcement officer, or military members breach a sworn promise to uphold the Constitution and faithfully perform their official duties. People, all you got to do is go on the DOJ website and see their official duties. The FBI, ICE, whoever it is, their official duties are there. Okay, and remember, okay, loyalty oath is a formal declaration of allegiance, specific government, state, or organization, typically requiring an individual to support the Constitution and disavow support for illegal or subversive groups. They are widely used across various sectors and are frequently challenged. Okay. Okay. How about we put here? What happened if the oath is broken depends on the concept ratio from loss of personal trust to severe legal or spiritual penalties. Consequences differ based on whether it's legal, religious, or personal agreements. Legal official oath is a legal proceedings. Knowing breaking a sworn oath leads to a criminal charge of perjury, which carries penalties or heavy fines of imprisonment. Elected officials violating the oath of office may face impeachment, civil suits, or criminal charges depending on the jurisdiction. Religious vows, professional and professional. Outside the courtroom or religion, breaking the oath destroys personal integrity. But violating the oath is also A violation of the oath is not automatically deprivation of rights, but it can be whether it depends on how the oath was broken or whether the action denies someone a constitutional legal right. A violation of an oath is a breach of a solemn ethical promise while breaking a sworn oath of office and carries severe administrative, professional, or political consequences, such as impeachment or being fired. It is not inherently a criminal civil rights violation. Deprivation of rights, that's what we're talking about now. This occurs when a public official acting under the color of law, using their official position, that's what it means, acting under the color of law, using their official position, willfully denies someone their federal protected rights, privileges, or immunities, and for that, their qualified immunity does not exist. They cannot claim qualified immunity for knowingly and willingly violating your constitutional rights. Taking orders, that's not a valid defense. Ignorance of the law, not a valid defense. Okay. So, yeah, violating the oath is, in the context you're thinking of, deprivation of rights. Them not being charged creates a conspiracy against rights under the color of law. All right, people, thank you for listening. I wish you nothing but peace and happiness. May your Creator always be with you and rain many blessings. Good night. Nothing but love and happiness.